The president of the City Bar Association, and I'm delighted to welcome Lanny Breuer to our podium tonight. This is the latest in our series of events where we invite top government officials to address the association. As you know, Lanny is the Assistant Attorney General for the Criminal Division of the Department of Justice, where he's been since 2009, and where he oversees the 600 attorneys who prosecute federal criminal matters all across the nation. He also works very closely with our country's 94 United States attorneys in connection with the many thousands of criminal matters that are investigated and prosecuted in their districts every year. I happen to know firsthand that Lanny did not always hold such a lofty position. That's because when he and I were right out of law school in the mid-1980s, we worked closely together as first-line assistant district attorneys in the office of Robert Morgenthau. There we worked tirelessly, often during the overnight lobster shift from midnight to 8 a.m., keeping our city safe from turnstile jumpers, squeegee men, shoplifters, and other threats to our public safety and economic security of our city, at least in our first year. While I left that position after a handful of years, Lanny stayed on, where he graduated into prosecuting violent crime and investigating white-collar offenses. In 1989, Lanny moved on to Covington and Burling in Washington, where he practiced until 1997, when he became special counsel in President Clinton's White House. Among his many duties there was assisting in defending the president in his impeachment trial thereafter. Lanny returned to Covington and Burling in 1999 as co-chair of the firm's white-collar defense and investigations group, where he specialized in white-collar defense and complex civil litigation. In 2009, Eric Holder had the good sense to lure Lanny back into the government in his present position as Assistant Attorney General. In this position, Lanny has a major role in shaping the administration's law enforcement priorities and policies, and that's what we'll be hearing a bit about tonight. He also regularly testifies before Congress and gives counsel to the Attorney General and the White House on matters of criminal law. Lanny also serves as the Justice Department's representative on the Atrocities Prevention Board that was formed this April to develop worldwide atrocity prevention and response strategies for the U.S. government. I could go on and on about Lanny, but I suspect you'd rather hear from him than me, so I'm going to turn it over now to Lanny Breuer.
Well, thank you very much. I'm delighted to be here, and Carrie's absolutely right. We both met in the Manhattan District Attorney's Office, and back when we started in 1985, when I started in 1985, Carrie started a year before, the DA's office had a system in place where you would have a junior mentor and a senior mentor, and Carrie actually was my junior mentor because he was very experienced. He had been there 1 year, and I was brand new, and it was under Carrie's great tutelage that some of his colleagues convinced me that when I was doing the AP9, which was Carrie doesn't know where I'm going, by the way, you can see from his face, but when I was doing AP9, which was something where you'd spend all day and you would get maybe 200, 300, 400 different cases that you'd have to process through, and you'd stand there and you'd read these jackets, and I had a dilemma. It was my second day, and I just didn't know what to do. What do you do when you really, really, really have to go to the bathroom? And that was the kind of thing Carrie's supposed to tell me, so they convinced me that what you do is you ask the judge's permission. And I did. I've come a long way since then. Carrie has really been a longtime friend, and I'm delighted to be here, and I'm really honored. There are many friends here, and I'm particularly honored to see Cyrus Vance, the remarkable district attorney, and an old friend here, Lauren Reisner, of course, who is one of the leaders in the Southern District, and so many others. So for me, it's really a privilege today to be here with so many of you in this really beautiful hall. I'm delighted to see you and delighted to have a discussion with you today. Even though I've now lived in Washington, D.C. for over 20 years, there simply is no place I feel more at home than in New York. I was born here. I was born actually in Manhattan. I grew up in Queens. I went to Newtown High School in Elmhurst, Queens, and then I went to Columbia College and Columbia Law School before starting, as Carrie said, my legal career in the Manhattan District Attorney's Office. So I was as New York can be. And so in looking around here, I really feel that whether you are a new member of the New York Bar or a more grizzled New York lawyer, you know that this city can be, in many ways, a very unforgiving place. But I like to think, and I think it's been true for me, that living and practicing law in New York prepares you for anything, even for living in Washington. It's a true honor to be with you at this Bar Association event. I have now, as Carrie said, been the Assistant Attorney General of the Criminal Division for nearly 3.5 years, which I'm told literally makes me now the longest-serving head of the division in nearly 50 years. The Criminal Division is, of course, based in Washington, D.C., and as Carrie mentioned, has approximately 600 lawyers that practice in roughly 15 sections. Division lawyers prosecute an array of federal crimes, from public corruption in our public integrity section to cybercrime in our computer crime and intellectual property section, to violent and organized crime in our organized crime and gang section, to financial fraud in our fraud section. Since 2009, my team and I have changed in many ways the division, I think in very significant ways, bringing in new and energetic leadership to our virtually every section and prosecuting the highest impact cases in the country. In particular, and relevant to what I want to discuss with you today, we have dramatically ramped up our white-collar criminal enforcement efforts, an aspect of our work that I care very deeply about, and really one that has never been more important to our nation. In 2010, I was fortunate enough to hire Dennis McInerney, who's in our audience today, a lawyer that I hope is well known to many of you. He was Carrie's former partner at Davis Polk, and he's been the chief of the Criminal Division's fraud section since 2010. Dennis has tremendous energy and tremendous skill, and together as a team, I believe Dennis and I have been able to hire many talented prosecutors into the section, from U.S. attorneys' offices around the country, many from New York, from top law firms, and from other places. The Criminal Division is lucky to have someone of Dennis's sophistication and experience leading our section, and I'm lucky to have him as my partner and my lifelong friend. Tonight, I want to discuss one aspect of our white-collar criminal enforcement in particular, the use of deferred prosecution agreements, or DPAs. Over the past 3.5 years, the Department of Justice has entered into dozens of DPAs and non-prosecution agreements, NPAs. I've heard people criticize them, and I've heard people praise them. What I'm here to tell you is that along with other tools that we, of course, all have, DPAs have, in my view, a truly transformative effect on particular companies and, more generally, on corporate culture across the globe. Though the U.S. Supreme Court blessed the concept of corporate criminal liability over 100 years ago in New York Central Railroad Company versus the United States, until roughly 20 years ago, we had only one blunt instrument, only one, a criminal indictment in which to attack and address corporate crime. Prosecutors therefore faced a stark choice when they encountered a corporation that engaged in misconduct: either indict or walk away. In the 1990s, however, the government began doing something new, agreeing to defer prosecutions against corporations in exchange for an admission of wrongdoing, cooperation with the government's investigation, including against individual employees, payment of a monetary penalty, and concrete steps to improve the company's behavior. And over the last decade, DPAs have become a mainstay of white-collar criminal law enforcement. The results has been, in my view, unequivocally far greater accountability for corporate wrongdoing and a sea change in corporate compliance efforts. Companies now know that avoiding the disaster scenario of an indictment does not mean an escape from accountability. They know that they will be answerable even for conduct that in years past would have resulted in a declination. Companies also realize that if they want to avoid pleading guilty or to convince us to forego bringing a case altogether, they must prove to us that they are serious about compliance. Our prosecutors are sophisticated. They know the difference between a real compliance program and a make-believe one. They know the difference between actual cooperation with the government and make-believe cooperation. And they know the difference between a rogue employee and a rotten corporation. In April of this year, for example, a former managing director of Morgan Stanley, Garth Peterson, pleaded guilty to conspiring to evade the bank's Internal Foreign Corrupt Practices Act controls. He was sentenced to prison last month. Because Morgan Stanley voluntarily disclosed Peterson's misconduct, fully cooperated with our investigation, and showed us that it maintained a rigorous compliance program, including extensive training of bank employees on the FCPA and other anti-corruption measures, we declined to bring any enforcement action against the institution in connection with Peterson's conduct. That, in my view, is smart and responsible enforcement. At the same time, when we discover more systematic and systemic wrongdoing within an institution, the corporation itself can face severe consequences. In the Siemens case, for example, in which we uncovered a company rife with corruption from top to bottom, we required Siemens AG and 3 of its subsidiaries to plead guilty to FCPA-related offenses. Siemens paid $450 million in fines in the United States, in addition to hundreds of millions more in civil penalties, and even more to German enforcement authorities, for a total of $1.6 billion. The company also had to appoint an independent compliance monitor for a 4-year period, and virtually the entire leadership of the company was replaced. And late last year, following extensive cooperation by the corporation, we announced indictments against 8 former senior Siemens executives and agents, including a former member of Siemens AG Central Executive Committee, the former CEO of Siemens Argentina, and that company's former CFO. You don't have to look further than the General Counsel of Siemens AG to hear someone state succinctly the problem that Siemens had. Quote, widespread corruption steered out of Germany. And he put it in, as he said in a recent interview. And that culture has changed dramatically in the years since the company owned up to its conduct. One of the reasons why deferred prosecution agreements are such a powerful tool is that in many ways the DPA has the same punitive, deterrent, rehabilitative effect as a guilty plea. When a company enters into a DPA with the government, or an NPA for that matter, it almost always must acknowledge wrongdoing, agree to cooperate with the government's investigation, pay a fine, agree to improve its compliance program, and agree to face prosecution if it fails to satisfy the terms of the agreement. All of these components of DPAs are critical for accountability. Perhaps most important, whether or not a corporation pleads guilty, as Siemens AG did, or enters into a DPA with the government, the company must virtually always publicly acknowledge its wrongdoing, and it must do so in detail. This often has significant consequences for the corporation, and it prevents companies from explaining away their resolutions by continuing to deny that they did anything wrong. In June, this past June, as has been widely reported, the Criminal Division's Fraud Section resolved allegations of criminal wrongdoing with Barclays Bank over the bank's role in the manipulation of the London Interbank Offered Rate, or LIBOR. The statement of facts appended to the NPA set forth the factual basis for the agreement in substantial detail, quoting from specific emails in which Barclays traders themselves asked Barclays rate setters and the submitters to manipulate their LIBOR submissions. As one trader wrote in an email to his submitter, "My counterparts in New York were screaming at me about an unchanged 3-month LIBOR. As always, any help would be greatly appreciated. What do you think you'll go for the 3-month? To which the rate submitter replied, "I'm going 90, although 91 is what I should be posting." As I said at the time, Barclays has paid a significant price for this egregious conduct. In fact, in the wake of our announcement, the top management of the bank was replaced. As we also recognized at the time, Barclays' cooperation with the fraud section's investigation was simply extraordinary. The bank voluntarily disclosed its misconduct, informed us of facts we did not know, and continues to cooperate in our ongoing investigation. We agreed not to prosecute Barclays in light of this extensive cooperation. Nevertheless, the consequences for the bank have been substantial. I think DPAs can be and are a remarkable tool. Another absolutely critical point is that regardless of whether we indict a company or agree to defer prosecution, individual wrongdoers can never secure immunity through the corporate resolution. There are, of course, times, and we all know it, when despite a company's admission of significant misconduct, we lack the evidence to prove that any particular individual committed a crime. But when we do have evidence, when we have what we need, we never hesitate to prosecute individuals, and they go to prison. In late 2010, for example, Alcatel-Lucent SA and 3 of its subsidiaries agreed to $92 million fine to resolve an FCPA investigation with our fraud section. We agreed to defer prosecution against Alcatel SA, and each of the 3 subsidiaries pleaded guilty. Did individuals get a pass? Absolutely not. 2 former executives were indicted. One of them has pleaded guilty and was sentenced to prison, and the other remains a fugitive. I have said before that the strongest deterrent against corporate crime is the prospect of prison time for individual employees. And we do not hesitate to seek long sentences when the circumstances warrant. Lee Bentley Farkas, the former chairman of Taylor, Bean and Whitaker, which was one of the largest private mortgage lending companies in the country, is serving a 30-year prison sentence for having masterminded a nearly $3 billion bank and securities fraud. And several of his co-conspirators are also serving substantial prison sentences. R. Allen Stanford, who misappropriated $7 billion from Stanford International Bank to finance his personal businesses, is serving a 110-year sentence. Roger Day, who defrauded the Defense Department of over 300 contracts, was sentenced to 105 years in prison. And Lawrence Duran, the former owner of a mental health care company, is serving 50 years in jail for orchestrating a $205 million Medicare fraud scheme. To be clear, the decision whether to indict a corporation, defer prosecution, or decline altogether is not one that I or anyone in the criminal division or anyone in any of our U.S. attorney's offices takes lightly. We are frequently on the receiving end of presentations from defense counsel, CEOs, and economists who argue that the collateral consequences of an indictment would be devastating, just devastating for their client. In my conference room over these past years, I've heard sober predictions that a company or a bank might fail if we indict, that innocent employees could lose their jobs, that entire industries could be affected, and that even global markets will feel the effects. Sometimes, though let me stress not always, these presentations are compelling. In reaching every charging decision, we must take into account the effect of an indictment on innocent employees and shareholders, just as we must take into account the nature of the crimes committed and the pervasiveness of the misconduct. I personally feel that it's my duty to consider whether individual employees with no responsibility for or knowledge of misconduct committed by others in the same company are going to lose their livelihood if we indict the corporation. In large multinational companies, the jobs of tens of thousands of employees can literally be at stake. And in some cases, the health of an industry or the markets are a very real factor. Those are the kinds of considerations in white-collar cases that literally keep me up at night, and which must play a role in responsible enforcement. When the only tool we had to use in cases of corporate misconduct was a criminal indictment, prosecutors sometimes had to use a sledgehammer to crack a nut. More often, much more often, they just walked away. In the world we live in now, though, prosecutors have much greater ability to hold companies accountable for their misconduct, conduct that we used to and often did ignore. And the results, to me, have been to be that we have a transformation in the culture of corporate compliance. In appropriate circumstances, large corporations such as Siemens AG must plead guilty for their crimes. In other cases, because the company has gone to extraordinary lengths to turn itself around, for example, or provided the government with extensive cooperation, a deferred prosecution agreement or a non-prosecution agreement may be the best resolution. No matter what, individual executives and employees must answer for their conduct. And perhaps most important of all, companies know that they are now much more likely to face punishment than they were when our choice was simply to indict or to walk away. Overall, the state of affairs is better for companies, better for the government, and better for the American people. So I want to thank you all for inviting me to speak. As Carrie suggested, I would be delighted to answer any questions. And I simply, before I end, want to point out that my Deputy Assistant Attorney General is in the back, John Beretta, who is another dear friend and great public servant. Thank you all so much.
So as you heard, Lanny is available to take some questions for a little while at least. So if you do have a question, please raise your hand and maybe stand up. I don't think we need the mic this evening, but if you could speak loudly enough for everybody to hear, that would be useful.
Well, of course, the U.S. attorneys themselves don't report to me in the criminal division, so the U.S. attorneys themselves, often through dialogue, often through discussions with us, I think, in the end of the day, try as best as they can to use a level of objective criteria. But your point is a valid point more generally, and I've made a speech to this effect, that if we look today at the sentencing guidelines, and we look today at sentences more generally, we see that in certain jurisdictions around the country, the great majority of sentences are within the guidelines, and in other jurisdictions and circuits in the country, you see something very, very different. And so in our federal system and in our system with 94 U.S. attorneys' offices and different areas, we definitely see a different perspective. I do think in the end, most deferred prosecution agreements are in relatively few offices, most of them, not all of them. And so to that degree, I think that in and of itself creates some level of uniformity. So you'll see, for instance, someone like Lauren Reisner from the Southern District, and I know he and our team will often consult. And so a lot of it happens through that as well. We try to be as objective as we can, but obviously at the end of the day, each case is different, and in each case we try to really rely on the very factors that I mentioned in my speech to try to come up with an equitable and fair resolution.